This is a list of questions that when you're the trial lawyer and you've got the cop sitting in front of you, how do you prepare that police officer for potential questioning? Now, we're putting aside the possibility of eliminate motions that could eliminate a lot of the cross-examination, but in this world of Google and lists that are being kept by public defenders and legal aid societies, we have seen sometimes prosecutors going into court and they're the last ones to know what's going on with their cop because the public defender has a list and or has also Googled the cop and found all kinds of stuff. So we prepared a list that to give our line trial assistants some guidance in how to talk to their cop about what information they may be in their background that could be considered giglio material. Now, this is, cops hate it when you ask these questions. In fact, it met with quite a bit of pushback in New York. We also distributed in our materials. After this was distributed, the NYPD issued a legal memorandum to their officers saying that the DAs have to ask these questions given our obligations to reveal the information. The first, our draft of this actually came from the U.S. Attorney's Office because we learned that the U.S. Attorney's Office in the Southern District of New York are partners where many NYPD officers would testify on various cases. They were being asked these questions by the AUSAs. So these are just, and again, these are in the materials. We give a little bit of a prelude to help the trial lawyer to explain to the officer why these questions are being asked. But you can see here that you ask the officer him or herself directly the types of questions that you need to know. I mean, this is like a step beyond what Eric, or another step for what Eric Zond was mentioning, which is when he actually is going to trial, he sends another letter. But here you sit down with the officer themselves. And I think the most persuasive thing to say to your officer is, I can't protect you from irrelevant, inappropriate questions unless I know these answers to these questions. So as you could see, we ask or we suggest, and we very clearly left the word draft in this list because there's no one way to do this. Cases are different, but it does help a line prosecutor figure out what's going on with this police officer. So have you ever testified before? Have you ever been convicted of a crime? And again, this is a New York requirement. Are there any civil lawsuits against you? Now, I must say on the civil lawsuit, some of our officers don't even know they're being sued. So there could be people they've arrested in their past who've sued them. They're being represented by the county attorney and they have no idea or no recollection. So sometimes they don't know that. This is any problems, internal investigations against you. Social media. This is a big one because this is one that a defense attorney can get access to if the officer has a non-public social media site. An example I give is there was a misdemeanor trial in Manhattan. It was a case where the cops had arrested somebody's child. The parents go into the precinct and the parents are outraged and they get into a fight with the desk sergeant, literally a fist fight with the desk sergeant over the arrest of their son. They get arrested for assault. At the trial, the prosecutor puts the officer on the stand, and the defense attorney gets up and says, Madam police officer is a woman. Do you have a social media site? Yes. And do you have a social media group that's called I Like to Punch People and Get Away with It? And the answer to that question was yes. So clearly, the defense attorney just did what one would expect. We're not used to going on social media for our police officers, but you never know what they can say and do. And so this, I don't know what possessed a police officer to create a social media group with that name, but they did. Um, and then we just have a series of other kinds of questions that will suss out the types of things that could come back to bite a police officer. So this is just getting very, very practical about it. Hopefully, all of this information is already known before you're at the point of preparing an officer for trial. But I just throw this out there as an example.
So for these case review questions, we started working on these many, many years ago, and they went through a number of iterations. Initially, it was designed really to be a reference aid for evaluating a case, and of course, for ensuring that prosecutors were meeting their disclosure obligations. And Chris, if you're able to scroll through it just a bit, when we first started talking about it, it seemed sort of onerous, and the attitude by many was, well, we don't have to disclose all of this, so why are we going looking for it? But what we found, and others have raised this point, and it's certainly truer now than it has ever been, that we wanted to ensure that the prosecutor wasn't the only person in the courtroom who was unaware of something exculpatory or impeaching and was going to get ambushed. And obviously, Chris gave the most extreme example of, I like to punch people in the face and get away with it. But certainly, in the context of a case where the defendant and the victim or witness are known to each other, there may be factors in the victim or witness's background that would bear on credibility that the defendant would know about, that the prosecutor wouldn't. Same thing, certainly with police officers, if the defense has done a more robust Google search, or even if the defense attorney on the instant case was the same defense attorney who cross-examined this police officer 2 or 3 or 4 years ago, and the judge made some sort of an adverse credibility finding on the police officer. So you can see these review questions go through a number of categories. And by the way, I'll back up. The goal here would be that during the pendency of a case, the prosecutor would review the facts of the case, would speak to the witnesses, speak to the police officers, and review this list with their supervisor, who would then initial and date it as sort of just for the file that this has been reviewed by a supervisor. And it's checklist worthy, along the lines of Atul Gawande's checklist manifesto. You can see that there are a number of different categories, and these were categories that were often reared their heads in the conviction review context. So we go through starting with identifications. Is there a non-identification? Is there a mistaken identification? Are there other suspects? Or is there scientific evidence that would point to somebody else as the perpetrator of the offense? Prior witness statements, be they inconsistent statements, be they denials about the identity of the defendant as the person who committed the crime, or denials about whether the crime actually took place. Certainly with accomplices or informants, this is really a shorter list, but it certainly serves as a guide for the kinds of things that prosecutors need to be considering before putting an accomplice or an informant on the stand. Um, uh, Mental and physical issues that might impair the victim or witness's ability to perceive an event or to see an event, to recall an event or describe an event, um, bias and motive to fabricate, benefits to victims and witnesses. Under the acts which affect credibility, this was a New York-centric document, and there was a sort of unusual appellate decision that came down probably 15 years ago now that basically held that in a case where the victim claimed similar victimization in an earlier case, that was something that would need to be disclosed, even if that prior case led to a conviction. And certainly in the context of digital evidence, the prosecutor should be reviewing with their supervisor that they have reviewed it, that they have gone through it, and what, if any, issues have come up there. And finally, are there any facts or information that would support a defendant's suppression claim? So again, this is really hopefully a helpful guide for prosecutors to use as they evaluate the strength, weakness of a case and their disclosure obligations.